So welcome everybody. My name is Nele Schuldt. I'm a final year PhD candidate affiliated with the DISSECT team at Ghent University, and it's my great honor today to open the proceedings to this wonderful event, a legal vernissage of sorts. This webinar celebrates the launch of the special issue of the European Convention on Human Rights Law Reviews, Winter Edition, December 2023 to be exact, titled The Evidentiary System of the European Court of Human Rights in Critical Perspective. Now, as part of the ERC-funded research project DISSECT with Professor Marie-Bénedicte Dembour as principal investigator, the examination and analysis of the various evidentiary regimes of human rights adjudicative bodies has been a constant companion to our research team, and it is ever enlightening and really exciting to exchange with fellow evidentiary scholars who presented at a webinar back in 2021. This event back in 2021 set really the groundwork for this special issue, where academics with very different research backgrounds managed to capture unique perspectives on the questions surrounding evidence. To reiterate the guiding questions we will discuss today, number one, how does evidence work at the European Court of Human Rights? How does the adoption of a particular standard of proof impact the outcome of cases? Is the burden of proof appropriately distributed amongst parties? And when does the court, in brackets, not consider facts established? Now, before handing over, I'd like to quote Professor Dembour in her editorial to the special issue, where she sums up, quote, "What clearly emanates from the special issue is that the court's evidentiary system is highly complicated, often confusing, surprisingly technical, constantly evolving, commonly inconsistent, and repeatedly stacked against the applicant." Now, let's find out today how this is not necessarily a critique of the court, which parts are indeed critical, and what lessons can be drawn from a closer examination of this case law. Now, without further ado, over to the first speaker, which is Professor Marie-Bénedicte Dembour. You have the floor with your presentation on, quote, "Beyond reasonable doubt at its worst, but also at its potential best. Ireland against the United Kingdoms, no torture finding dissected." And Marie's presentation will be discussed by Dr. Vassilis, Tzevelekos from the ECHR Law Review and University of Liverpool. Over to you, Marie.
Okay, thank you very much, Nele. So I'm going to talk to you today about the Ireland versus United Kingdom case, which is, of course, extremely well known for anyone who is familiar with the ECHR system. So what you probably know about it is that it's about what was called the 5 techniques. The United Kingdom subjected 14 presumed IRA terrorists to hooding, standing against a wall with your fingers against the wall and your heels up, being deprived of water and of food, being constantly subjected to a hissing sound, and being deprived of sleep. Famously or infamously, the European Court of Human Rights decided that this treatment did not amount to torture because it was not sufficiently intense in the suffering it inflicted. Instead, the court found that it was inhuman and degrading treatment. Now, just to say, the case was also about other complaints, but I'm not going to talk about those. What I'm interested in is that it's the first case where the court declared that it would use the standard of proof beyond reasonable doubt to decide whether the factual allegations were actually established. And it also said, and that's also rather widely known because it's often repeated in the jurisprudence of the court, that this BRD standard, BRD, beyond reasonable doubt, I will call it BRD, this BRD standard could be met through inferences and that within these inferences, it would be important to take into consideration the conduct of the state, the respondent state, as the proceedings to establish the facts were taking place. Now, interestingly, and I think not very well known, certainly I didn't know it until I started to look at the case, the United Kingdom really dragged its feet during the investigation phase of the proceedings. Dragging its feet maybe is putting it a little bit lightly, as some of the dissenting judges said. The United Kingdom really put up a wall of silence. What did this wall of silence consist in? The United Kingdom told the members of its staff, the members of the government, the authorities, including the security service, that it should not accept to be interviewed by the European Commission on Human Rights, which was establishing the facts. It also said that if by any chance they were nonetheless going to accept to appear before the Commission, they should not answer any question related to the 5 techniques. Further, the United Kingdom refused to transmit the files of the domestic proceedings, which went on after the 14 individuals subjected to the 5 techniques brought compensation proceedings. They actually received a very high level of compensation before the domestic courts, but the United Kingdom refused to show the Commission what had really been said during these proceedings. It also refused to transmit the interrogation files of the individuals. It did not even let the Commission know where the techniques had been applied, so physically the location, let alone who had authorized the application of the 5 techniques. In fact, it transpired later on that this had been authorized at the highest level, at ministerial level. So basically, the United Kingdom did not want to facilitate the investigation of the Commission. What did the court say in this very, very important case? First interstate case decided by the court. As I already said, it declared that it would use the BRD standard. Very, as far as I'm concerned, very understandable. These are serious allegations. One can really understand why the court would not find a state in breach of such a violation on a flimsy factual basis. It needs to be established. That's what the European Commission of Human Rights had also said before the European Court. Importantly, though, this BRD standard can be found through inferences. That the court said as well. To me, that makes a lot of sense, even though some commentators at the time said, well, if you're going to talk about BRD, you cannot accept inferences. It's not good enough. You really need direct evidence then. I side with the court in saying that if the inferences are serious, concordant, go all in one direction, then the reality may well have been established beyond reasonable doubt. To give you a very simple example, if I come back home and I know that the door of my house is blue and suddenly I find it is red, but in every other respect, it's exactly the same door. I recognize it. It has not changed. I've not seen the act of repainting, but I must infer the door has been repainted. So what I want to insist upon is that personally, I really have no problem thinking that BRD can be achieved through inferences. Obviously, the basis for the inferences then must be evidenced properly. Now, what is really interesting in the Ireland versus United Kingdom case is that actually the court drew no inference whatsoever, despite what I have told you about the behavior of the United Kingdom, and despite having said in its pronouncement that it would take into consideration the conduct of the state. So the question is why? Why did the court find no inference? And my hypothesis is that the court did not want to find the United Kingdom in breach of the prohibition of torture because it felt too big a fine. In other words, either the court did not want to see the reality or it did not want to draw the implications of seeing the reality of what had happened. So if it really did not see this reality because it found that there was not enough evidence, it would have made sense for the court 30 years later, when Ireland brought a new case before the European Court of Human Rights, saying that it wanted the court to revise its original judgment because new facts had been discovered thanks to the release of the government archives after 30 years, so that by then it became clear from the archives that the techniques had been authorized at ministerial level and had occasioned a very high level of suffering in the knowledge of the authorities already at the time. So the court could in 2018 have revised its judgment of 1978, but it refused to do that. And so again, it seems to me the court cannot have it both ways. It cannot be that either it did not know the facts because they were hidden from it. If that is the case, as I said, it should have been revised. Or if it knew the facts, if it had understood the seriousness of the matter, it then should have found the UK in breach of the violation of torture right from the start. It seems to me, and that's what also some of the dissenting judges say, that simply the court did not want to find the United Kingdom in breach of such a serious violation, because then there might have been a backlash on the part of the United Kingdom towards the court. So in that sense, what the court was doing, you could say, was to try to save itself by saving the respondent state, which in my article I call raison d'etat, which then turns into raison de cour. Okay, now returning to evidence, which is really what interests me, because at the moment this is the topic of the research project that I'm leading, with acknowledgement to the ERC for funding that project. So many thanks on that. So about evidence, I think—
2 minutes, Marie.
Thank you. The important point is that I have no problem with the court having used BRD. Some dissenting judges in other case law have said it was too high a standard. I don't think it's too high a standard, but then it must be used, if you like, in a virtuous manner. And I will show you what I think that entails. Let me try to share my screen here. Ooh, I thought I was well prepared. Why?
Right next to leave button, there's the share option. Yeah. Right.
Okay. Do you see something? No, I don't think that was.
Yes,
that
we see your slide indeed.
You see my slide? Okay. Thank
Yes.
you. Great. Thank you very much. Whew, I don't see it now, but let me go. Maybe if I go here. Okay, you see my slide. So do you see that BRD is to be approached as a Strasbourg sui generis autonomous concept? Yeah?
Yes, we see point 1 from your slide.
Okay, great. So that is not controversial. It's not a concept to be used as in the common law in criminal proceedings. Inferences must be recognized to be theoretically able to meet the BRD standard. Again, something the court has said. Importantly, inferences must be drawn in practice, which is where sometimes there are problems. Now, if the reality of the violation is established BRD, even through inferences, then the court should not suggest that there has been a shift in the burden of proof, because actually the burden of proof has been, in a sense, supported by the applicant completely. Now, any shift that in the burden of proof then must happen because of evidence which is not to the BRD standard, even just prima facie evidence. Otherwise, there is no point in shifting the burden of proof. Also, the court must be very clear on the fact that it is using an array of different standards. There is not only BRD in the Strasbourg case law, we also use preponderance of evidence or prima facie, for example. Each time, the court must be clear as to why it is imposing BRD onto the applicant and whether it is feasible. It must do the same when it imposes BRD onto the respondent state. Obviously, in all that it is doing, it must always be its inspiration and intention to protect human rights. And as part of this, then, it should not let itself be driven by raison d'état, raison de cour. So these to me are the conditions which if fulfilled, mean that BRD would be a completely fit standard for use in international human rights adjudication. Thank you very much.
Thank you so much, Marie. Over to Vassilis Tzevelekos for a brief response. We have about 5 or 6 minutes from you, if that's possible, and then we have a few minutes, around 5 minutes, for personal Q&A. So over to you.
Thank you very much, let me start by thanking Marie both for her paper and the presentation today, but also for leading this very important project. And I think I'm speaking also on behalf of Kanstantsin to thank her also for the hard work that she has put for this special issue to be delivered, and in particular for her diligence and eye for detail. The second preliminary point is that I think that the project, the DISSECT project, and then part of which is reflected then in this special issue, is very important both from a theoretical point of view and from a practical point of view. And I think that this is, for this reason, it will be also very useful for practitioners, people who are practicing human rights law, in particular before the European Court of Human Rights. So after these two preliminary points, let me get into the substance of Marie's paper and say that for me this is a truly excellent paper. I have a slight disagreement with we have discussed with Marie also when I was one of the reviewers, the eponymous reviewer, next to the two anonymous reviewers of the paper before this was published. But leaving this aside, I think this is a truly excellent, a very rich paper that manages very successfully to do two things. First, to criticize the two judgments in the Irish case, and second, through this, to theorize on BRT. And in this respect, I have a few points with regard to the merits of the paper to make. The first one is the first set of merits is that I think in theorizing BRT, Marie manages to show very successfully the relationship between BRT and common law and civil law, the two legal traditions. She criticizes and she discusses very successfully if and to what extent BRT is opposite for human rights law. And she raises, in this respect, questions such as burden of proof or the usefulness of inferences, so that the European Court of Human Rights can, in a sense, create its own sui generis, as I said, BRT
yes, this is closing
for the purposes of human rights.
The restaurant, it's closing the hours that we want to go.
So next to these merits, I would like to move to another of a couple of other merits of the paper, which are not that explicitly elaborated, but if one reads between the lines, I think that the point is clearly made by Marie. The first such point is concerns, in a sense, double standards. I know that Marie doesn't use this term, but when she compares the Greek case where torture has been found, as opposed to the Irish case, then one might wonder, knowing also how political these type of cases are, if this is an instance of double standards, because you have, I'm not saying that the facts are similar or that the techniques of torture are similar, but there are many other aspects where you can compare the two cases. And in one case, the commission at the time finds torture. In the other one, the contact falls short of contact, and this is quite telling. Why? Also because in one case you have a dictatorship, and on the other case you have a very well established, a very mature democracy, which is presumed to act in good faith. And this is my second point with regard to a point which is in a sense implied by Marie, but not explicitly using the terms that we'll be using. Nevertheless, she makes clearly reading the paper by Marie, my overall impression is that the point that she's also making is that the court treated the UK with respect, thinking that or considering that this is again a well-established democracy which is acting in good faith. Marie talks about intentions, but I think that the other word that could be used is good faith. And this is particularly important nowadays with regard to liberal democracies, the case law on Article 18, etc., etc. So just to finish with this part, I think that because Marie, using this case study, manages to theorize BRT, and she makes a number of excellent points, and because through comparison and through critical evaluation of this case, she also manages to make a number of other pertinent points with regard to double standards and good faith. I think these are merits of the paper that should be highlighted. Now, with regard to the key argument, I have one slight disagreement, as I said at the beginning, and one suggestion as to how this, in particular, the conclusions could have been more playful. So Marie does not say that BRT is not opposite. Marie says that BRT has not been correctly applied, in particular in the 78 case, and that this was done because of the raison de cour, the court dealing with a political case, wishing to achieve certain political goals, which required that no torture would be found. Now, I think that in doing this, and in particular when Marie argues and she shows that the court did not make the necessary inferences and it did not actually treat the facts of the case as they should have been treated, in a sense, she also applies this BRT method of evidence, and she's also making an inference. So she could maybe have used in the conclusions the analytical scheme that she has developed, because essentially she is also applying this in order to accuse the court of mistreating intentionally the facts of the case, so that the conclusion is no finding of torture. This is just a suggestion, and now the more critical point, and where most probably I slightly disagree with her, although my disagreement is mitigated, and I'll explain this. In the feedback I gave to Marie, and I guess I was not at all original in that respect, I told her, okay, why you say that the problem is with BRT and with evidence and facts, and it is not a question of definition of torture, because the concept is evolving, because at that time the threshold of gravity was lower, and etc., etc. And Marie, I think she acknowledges this, and she says that this is a critique that she has received from various scholars, including very authoritative scholars and persons who have been involved in the court and in these cases. And she tries to make the argument that it is not torture, it is not the definition of torture, it is evidence. The problem is with the way the court assesses the facts and makes inferences. In this respect, I think that it would be worthy if Marie would make one extra step and, in a sense, replicated what the court should have done by assessing these facts and then establishing whether still torture, that the threshold of torture is met, considering in particular that this is a judgment that was delivered many decades ago, and that, again, torture, the concept is evolving, etc., etc. So my key point, and I'll sum up with this, I will finish with this, is whether in the end it is not only a question of BRT and evidence, but it is also a question of the definition of torture as this was defined, as this existed at that moment, at that time. Because, and to make this point, I think that it would be necessary, this extra step, showing how these facts would meet the definition of torture at that particular time. I'll stop here by thanking again Marie and all authors in this special issue, and by also seizing the opportunity to thank many of the participants, because in different capacities they are contributing to the ECHR law review. Some of the participants in this workshop today are members of our boards. Some others have acted as anonymous reviewers. So many thanks on behalf of the ECHR law review to all of you for helping us with this special issue and with the ECHR law review in general. Thank you.
Thank you so much, Vassilis, and welcome, Kristin, as well. If you could turn off your camera for now, just so we have a bit of an overview of, for the recording. Marie, would you like to briefly respond, or would you like to yield your time for some Q&A? We have a couple of minutes left.
Thank you. I think I will respond, and I will first want to thank both Vassilis and Kanstantsin for being such supportive editors of someone like me who was putting a special issue together. I mean, I've said it in my acknowledgements. I've told you that also privately, but you've really been a model of support. So many, many thanks. Now, going to the substance. I cannot countenance the idea that the court in 1978 could not see that the United Kingdom was not acting in good faith. You know, the Commission was very, very clear that the United Kingdom had been obstructive at all times. And the court did not acknowledge that. And it went as far as, well, not explaining in which way the United Kingdom had obstructed the proceedings. It also failed to mention that there had been a medical expert for the Irish government who had actually testified that the consequences of having been subjected to the 5 techniques was as bad as being subjected to Nazi torture during World War II. So it was a very, very strong testimony, a very, very strong expert opinion, and it's not mentioned in the judgment. So it's completely silenced by the court. So I think that the bad faith of the UK government was clear to be seen, and the court did not want to act upon it. That's my view. Now, double standards, was that because of double standards? I would expect so. The United Kingdom was a very, very important state. So, yeah, the court did not go there. As far as Greece is concerned, yeah, I mean, the Commission found torture, but then the case did not come before the court. So I don't think we can say there that we don't know what the court would have said, would be what I'm saying. I don't know whether the court would have found torture or not. So that's my response to the double standards. In terms of the slight disagreement that Vassilis has, and that other people, as he said, have also brought to my attention, including the 2 anonymous reviewers. So in that sense, there was quite a bit of unanimity. I find it very difficult to think that the definition of torture, which was being used by the court at the time, and which rely on having a very intense suffering, which still is the case, of course, that has not changed, that the court could genuinely have thought that this threshold had not been reached if it had known the facts properly. And either because the United Kingdom would have been clear about the treatment and their effect, or because it could read between the lines what was happening. So yeah, it's commonly said, oh, at the time the court did not realize that torture does not necessarily lead to physical wounds, that it can also leave no physical trace and still be intense suffering, which is going to have long-term effects, which are extremely serious. Well, a lot of people were already aware of that at the time. So it's not that it was an impossible thing to acknowledge. So to me, I find it difficult to follow that reasoning. To me, the definition of torture, which was used by the court, the understanding of torture potentially as having to leave physical scars, would have been another way for the court to manage not to find the United Kingdom in breach of the violation of torture. I mean, I can add also that today, even so, we accept the judgment. The judgment was not revised, and the judgment was not revised on the official grounds, on the judicial grounds, that the definition of torture at the time used by the court in 1978 was not such as to lead to the conclusion that the 5 techniques were torture. I think, to me, it's not convincing because the severity of the suffering was already there. So had the court either known directly or acknowledged through inferences the severity of the effects of the 5 techniques, it would have been led to find that there was torture. So to me, it's still this idea of BRD inscribed in the judgment is still about kind of distancing, making it possible to kind of suggest we the judges don't really know what has happened. We don't know enough. It's not secure. And I think that, in fact, it was very clear. It was clear to the Irish government, to the European Commission on Human Rights, to Amnesty International, to lots of different actors already at the time. So that's why, in a sense, I developed my argument in the article as I did. Voilà, Nele. This is my response.
Thank you so much, Marie. And I'm curious to continue this perhaps in the general Q&A. I think we should move forward because we will not have time to have both a question and a response. So I would hand over the microphone to Professor Kristin Henrard. Thank you so much for being with us today. You will be presenting on your article called The European Court of Human Rights and the Special Distribution of the Burden of Proof in Racial Discrimination Cases. The Search for Fairness Continues. And the discussant at the end of your presentation will be Professor Kanstantsin Dzehtsiarou from the ECHR Law Review and University of Liverpool. You will have 14 minutes. I will give you a 2-minute timer at the end of your presentation, or just before the end of your presentation. And over to you.
Thank you very much, Nele, for this introduction. Thank you, of course, also to Marie-Bénedicte Dembour for the initiation of the special issue of the journal and organizing this workshop. So indeed, as the previous presentation already emphasized, in terms of realizing the effective protection of fundamental rights, it's incredibly important that there's a fair distribution of the burden of proof, more particularly something in relation to the burden of persuasion, exactly. And in that respect, it is important that, particularly in relation to the prohibition of discrimination, the understanding that it was very difficult often to put forward full proof, that there was this development of the so-called shared burden of proof, or the special distribution of the burden of proof. Now, what does that mean? It actually cuts the whole process in two phases. And this means that it's only in the first phase, in the prima facie, to establish a prima facie case, that the burden of persuasion is on the claimant. So indeed, the claimant needs to prove the facts that persuade the court that a prima facie case can be established of discrimination. Once the court establishes such a prima facie case, then the second phase, the rebuttal phase, goes in. Here, the burden of persuasion lies on the defendant, on the state, that then needs to persuade the court that no discrimination took place. And so this facilitates overall the burden of proof of the claimant. Now, when we look at the jurisprudence of international and national courts, we see that these principles are widely shared and can be considered to be visible. Nevertheless, the actual criteria for either phase are still being developed, and then more particularly, what amounts to the prima facie case? When do you have that? Because that's the tipping point, of course, between the first and the second phase. Now, after some really brief reflections on evidentiary principles at the ECHR, my main point here is to emphasize the different development lines in relation to the use of the special distribution of the burden of proof between direct discrimination on the one hand, indirect discrimination on the other hand, focusing on racial discrimination. The point being that you can look in terms of indirect racial discrimination, the search for fairness in terms of the distribution seems to be one of fine-tuning mainly, whereas when we look at direct racial discrimination cases, there's still a long way to go. And there's three problems that I want to emphasize and want to lay out a little bit before you, to then come to a conclusion. Right, so starting with these evidentiary principles at the ECHR more generally, as Marie already also emphasized, that the court uses this beyond reasonable doubt standard, which at first sight seems to be very demanding because it's borrowed from criminal law. Nevertheless, we can see that the court can obtain a fair result because it has ways to use that standard in a flexible way. For example, there's a free evaluation of all evidence for the court, and it is willing and able to take inferences and presumptions on board. So it is not as such impossible in fairness in saying this standard. Now, second point that I want to make here is that actually, if you look at the two phases that I just laid out for the special distribution of the burden of proof, this is in line with the court's overall assessment in terms of human rights violations. First, the establishment of an interference with a fundamental right, so the prima facie case, then the limit checking whether the interference is justified or not, and so the possible rebuttal phase could be aligned to that. Now, the central point here that when you look at cases in terms of racial discrimination in particular, there's a striking difference in the extent to which the special distribution of the burden of proof has been already realized. Indirect discrimination, fine-tuning, mainly direct racial discrimination, there's still a long way to go. Now let's first consider this distinction between direct and indirect discrimination. You can say, well, maybe the difference has to do with the fact that these types of discrimination are very different. Look at EU law, and EU law has a very different type of justification possibility for both. So that seems to point in that direction, confirming the different nature. In international law, there is not a different justification system, but also there we see that there are some courts that have been very reluctant in recognizing this notion of indirect discrimination. So what about the different nature of these two types of discrimination? Indeed, indirect discrimination has more of a group focus and concerns a disproportionate impact on a particular group. Hola, something goes wrong. How do I go back? I'm a bit... Okay, there we are. Sorry about that. Yeah, no, I'm there. Yes, I'm there. The different nature. This is where I was. Exactly. So on the one hand, indirect discrimination has a more inherent group focus compared to direct discrimination, whereas the causal relation between the disadvantage on the one hand and the protected ground on the other hand is way more indirect with indirect discrimination than direct discrimination. Okay, that may be the case, but we all know that the differences are not that big after all. We all know that direct discrimination is an expression of or is related to questions of prejudice, stereotypes against a particular group, and that if we talk about the directness of the causal link, that's a question of degree. It's a sliding scale. So let's look at the two lines, the two different types of discrimination and what the court does in terms of the burden of discrimination and the distribution of the burden of proof. Excuse me. So indirect racial discrimination, there we actually go from the court initially struggling with the notion of indirect discrimination, and it's only through the slow development of the special distribution of the burden of proof in a way that would not impose too heavy of a burden on the state. Once the court was satisfied with having found that it could actually acknowledge the notion of indirect discrimination. So both processes, the acknowledgement of the notion and the development of the special distribution of the burden of proof for indirect discrimination go very much hand in hand. And to some extent, you could say, well, you know, the court has been traditionally very reluctant for discrimination in general, but nevertheless, the fact that the indirect discrimination had such the group focus and way more attention for the contextual information, of course, wasn't very well aligned with the more casuistic approach of the court in general. Now, over time, the court's reluctance towards discrimination and finding discrimination reduced. Klimenos is often said to be a very important case in this respect. But at the same time, Klimenos also opened the acknowledgement towards recognizing that, you know, neutral norms may be problematic because they have a disproportionate impact without justification on a group, even when there's no intent. So this went a little bit hand in hand, this development. Nevertheless, still, there was a profound uncertainty about a fair distribution of the burden of proof. And the court kept hinging on that. So it stopped it from actually accepting the notion as long as it felt this uncertainty about the burden of proof. How can we see that? So this was really, you can see the court's concern for not imposing too big of a burden on the state that actually explained the slow development of its embrace of the notion of indirect discrimination. And particularly this whole question of what is the role of statistics. And the court kept saying, well, it's not enough, without specifying what more was needed. And it's just gradually that statistics became an accepted element. And more particularly, and the court was emphasizing, yes, but then they need to be of a certain quality, and certain quality demands were important. Convincing official statistics, the court said, or statistics that appear on critical examination to be reliable and significant. And that is really what the court emphasized. But then over time, once the statistics were more or less part of were ingrained in the jurisprudence, you see the court takes further steps, further fine-tuning in its search for fairness. Okay, even when the statistics in themselves are not convincing, it's still possible to have regard to reports of expert bodies, or the court says then it can still make inferences. And so the court gradually becomes more confident in using the special distribution of the burden of proof. So what we see overall is that the ECHR coming to terms with the notion of indirect discrimination basically hinged on its finding a fair distribution of the burden of proof, with particular attention to its concern for the state. And so now we're in a phase of further fine-tuning mainly. When we go and have a look at direct racial discrimination cases and what happens there, a very different picture emerges. Okay, when it's a case of overt direct discrimination, then it's fairly easy to find a prima facie case. So that's easy. There's either a question of an official order or something that can be pointed to. So these overt cases, they're not too complicated. It's more increasingly the fact that we're dealing with covert direct discrimination. So, and then what? And so then it is all the question like, you know, is there then proof of discriminatory intent that is necessary? Here, we need to acknowledge that on the one hand, the European Court of Human Rights has always emphasized that it doesn't require proof of discriminatory intent for a prima facie case of direct discrimination. However, you know, when you need to prove a direct causal link in a covert case, it becomes actually very close to demonstrating discriminatory intent. And then the problem is, once criminal law at the national level kicks in, you can't work with the presumption of discrimination, because that would run foul of the presumption of innocence in criminal law. And so again, there's this concern that there is no impossible or unreasonable burden be put on the state. So here we see an ongoing struggle in direct racial discrimination cases to reach a fair distribution of the burden of proof. And three problems can be highlighted. I lay them out here and then I'll discuss them one by one quickly.
Yes,
so
Kristin, just to interrupt, 2 minutes left. Thanks.
Ooh, you are kidding. Okay. So there's lack of guidance on the parameters to establish a prima facie case, and there's actually suggestions can be made that the threshold is too high to reach a prima facie case, which is visible in the confusion between a prima facie case and full proof. And there's a failure to explore possible inferences from problems with the procedural investigation duty of the state with actually discriminatory motives for state officials. So ultimately, what we see is that the concern about not imposing too high demands on the state in these matters tends to outweigh concerns for an improper burden of proof on the claimant. So lack of guidance, here I need to go back to this question of the Nachova case, which was quite key here, where the Grand Chamber reversed the reasoning of the Chamber. So unlike the Chamber, the Grand Chamber didn't accept that because of the flaws in the investigation, there was also a problem in terms of substantive violation. Nevertheless, the court here identifies three criteria of relevance: specificity of the facts, gravity of the allegations, and the infringed rights. Now, the point being that, well, an important point here is that the court in this Grand Chamber decision also launched the very important procedural dimension of the prohibition of discrimination related to positive obligations in terms of investigation. However, and notwithstanding the promising thing of these three criteria, the court never actually operationalized them. Now, my point is that the guidance here is really possible. If you look at the three criteria and you look at the practice of other courts, specificity of the facts seems plausible. The more detailed the facts, the easier it would be to establish a prima facie case. Seriousness of the allegations, indeed, also that is accepted. The more serious they are, the more demanding one can be in terms of the burden of proof. The convention right at stake, that is more in favor of the claimant. Potential discussion of the hierarchy of rights. There may not be a hierarchy. Nevertheless, it's quite clear that also in the jurisprudence of the court, certain rights are emphasized to be of particular importance. Like racial discrimination, it's supposed to be particularly, or it is said to be particularly invidious, needing special vigilance, etc. Now, that was per part one. So point one, there are these 3 points, these 3 criteria that could have been developed. The court hasn't done so. More particularly, if you see what the court is doing, it often seems to be confused between what is required for full proof and what is required for a prima facie case, in the sense that, and that makes you then assume that the threshold it de facto uses for a prima facie case is too high. And there are several cases where, on the one hand, the court's reasoning seems to actually acknowledge that there's quite strong proof of racial violence by the police. But nevertheless, the court then simply says that there is a prima facie case. So that seems to point to too high a threshold. Bringing me to my third problem, and that is that procedural state obligations, however important they are, these investigatory obligations to unveil possible discriminatory motives, it is important to also acknowledge that there may be inferences with the actual substantive violation of discrimination. So as I already flagged the in principle importance, so it's important that there is now also the procedural dimension that is recognized, in the sense that when a court hasn't fulfilled its procedural obligations to investigate possible discriminatory motives, it could be held in violation of the prohibition of discrimination in the procedural dimension. So at least there is, at the level of the ECHR, a violation that is established of discrimination. And it also has the advantage that at a national level, this could actually produce more proof for the claimant to use. This is particularly the case as the court seems to become more and more demanding of what it actually requires in terms of the investigations duties on the side of the state. Sometimes some of the judgments seem to be really a CSI manual, even like really very detailed. Nevertheless, what the court has failed to do so far is recognizing that in case of systemic discrimination, the lack of proper investigation could actually already point to discrimination in itself. So this question of interferences needs to be looked at again. Bringing me to my conclusion, starting from this thing doesn't work. Navigation forward somehow. Now this one works. Okay. So promising starting point, and this two-step analysis of human rights obligations of by the court is actually in line with the two phases of the special distribution of the burden of proof. So you would expect that the court easily makes use of that because it seems to fit. Nevertheless, a striking different development was noted for indirect racial discriminations versus direct racial discrimination cases. And in both cases, actually, the development or lack of development for direct racial discrimination can be pointed to too great a concern for putting too heavy a burden on the state. And this imbalance, actually, then basically leads me to the conclusion for the court, a call on the court to rebalance. And how rebalance, more particularly in relation to direct racial discrimination cases. So provide more guidance about what is required for a prima facie case without putting the threshold too high, and indeed exploring possible inferences between flawed investigations towards actual substantive discrimination, partially returning to the Nachova chamber judgment. So thank you very much for letting me finish, although I may have gone a little bit over time, but these were the lines of my my presentation. Thank you.
Thank you so much for your rich presentation, and straight over to Professor Kanstantsin Dzehtsiarou for some responses. We have until around 10 past, quarter past at the max. So it's over to you from now on. Thank you.
Thank you very much, and thank you very much indeed, Kristin, for allowing me to read your very important contribution, and it's good to see. It's been like many years since I've seen you last time. The sun decided to shine in Liverpool. That happens very rarely, but it also creates rays of wisdom on the screen. So I hope that it will add to what I have to say. But before I go into my short short remarks as a discussant, I wanted to say thank you to Marie, of course, for putting together an incredible special issue, and it's a lot of work, of course, for editors to do that. And I also wanted to say thank you to Nele, who is, I can see, keeping order very well. And if I go over time, please, I give you full permission to mute me, because I'm not going to say anything very, very insightful too. Thank you very much. So
one before you start, Kristin, maybe if
Shall
you
I
can
sharing
your presentation, maybe, because then it will be nicer for the recording. Thank you.
Okay.
Over to you.
Thank you very much, Marie. Okay, so let me get straight to the paper, which, as I said, is very rich and super interesting. And while reading this paper, I was surprised a couple of times. And I thought that I've been in the business of ECHR for quite a while, that it's very difficult to surprise me. But Kristin, you managed to surprise me with a couple of important things, I think. The first one is this intuitively not very straightforward point that actually the European Court of Human Rights managed to deal with indirect discrimination better effectively than with direct discrimination. Usually one would think that direct discrimination is a much more straightforward thing to prove. It is something that doesn't require layers of evidence to be provided, but prima facie, using your terminology, it is much easier to substantiate. However, you make a very, very good point when you try to actually look into this assumption, and that proves that these assumptions are not always correct, and this is one of those cases. So I do understand that a bit of complexity in relation to direct discrimination, as the fact that some of these forms of direct discrimination are covert, and they need further unpacking, and that perhaps is part of the answer to my initial observation. But still, having indirect discrimination, which is perhaps the most complex out of all of them, is dealt better with the court, was my surprise when I was reading it. The second kind of semi-surprise was a very interesting point about connecting proportionality and the burden of proof. I have never thought about proportionality as the way of redistribution of burden of proof, and this seems like a very interesting way of repackaging proportionality. So when you say that, for example, that establishment of interference, effectively the first step of proportionality test, is initial prima facie case from the perspective of evidence, and I thought that it's really good and very interesting way of dealing with the test of proportionality through the prism of evidentiary burden. I thought that it's very good, but surprising. However, here I have a slight, not disagreement, but an invitation to think, so to speak. So in passing, it was mentioned in the paper that actually establishment of interference is a presumption of a violation, right? So like this establishment presumes that a violation has been committed by the respondent state. I thought that presumption in this case is a little bit a stronger word that I would use, because the court actually just goes through the first step of the evidentiary analysis, rather than presumes immediately as soon as there is a violation, presumes as soon as there is an interference, presumes that there is a violation. I found that a little bit too quick a conclusion to make before all actually things are considered. The third surprise was about the statistical argument, the argument about using statistics in in cases of indirect discrimination. I, non-expertly thought that the court immediately arrived at the point of DH and Orsus and cases like that and established that here we are. This is how statistics should be used. But not like it was a very long and very important development. And I learned quite a bit in that respect because I never looked quite into this issue of development of statistics, and this is a very, very significant contribution, I think, of this particular paper among many others. My final point, and I don't know how well I am doing with time. Hopefully, I will not be excommunicated from Teams right away. But my very quick final point is about the distinction between prima facie case and full proof. I found this idea very fascinating and very interesting. But I was also thinking about the fact that, Kristin, you are relying on the way how the judgment is presented. So you say, okay, in this prima facie, this is actually, instead of prima facie, this was a full proof and the court. But what does full proof means? Does it mean that the state should not even be given an opportunity to respond to a particular point of racial discrimination? So basically, in my view, and you might want to do, you know much better, and you might want to disagree with me. In my view, is just like perhaps a way that the European Court of Human Rights, in its judgment, is presenting this evidence, and sometimes this evidence are much higher in terms of persuasion, sometimes they are lower, but I'm not entirely sure that if we have full proof and like say that this is an absolute 100%, there is no way for the state to get out of this, the state is not should not be given an opportunity to check. What is more important, given an opportunity to respond, what is more important is to see whether this actually full proof led finally into the violation or not. So this is my last substantive point. I think it is, but like the very last question that I have, and I know that like I'm cheating a little bit, and Nele is probably checking her watches right away. But very quick, if we remove racial from discrimination, would anything change in your article? Except for illustrative examples, okay. But is this point that you're making relevant only to racial discrimination? I was reading throughout the paper and was thinking like, would that be applicable across the board to other types of discrimination? Thank you very much. I learned a lot from your paper, and it's incredibly rich. And I would recommend all my students who are dealing with discrimination to read your paper. Thank you very much.
Thanks so much, Kanstantsin. And 2 minutes for Kristin, if you'd like to respond. And perhaps you can just pick one of these questions to respond to and then keep the rest for the general Q&A. You're very welcome to come back to some of these points and elaborate on them if you'd like. But for now, 2 minutes, over to you.
Thank you very much, Nele. So thanks a lot, Konstantin, for your elaborate considerations. I really enjoyed them, actually. As to your first point, I think that is, I do want to say something about it. That's exactly the gut feeling you would have. But as soon as it's about, racial violence or same thing, ethnic profiling, there you see the same thing. The whole question of the direct causal link then concerns the question of intent, and proving intent is incredibly difficult. So there, the whole thing of the prima facie case, and so the two phases and of the special distribution of the burden of proof becomes incredibly important. So yes, but I think that is exactly the gut feeling most people would have, but if you look at the actual facts, it's different. I do agree with what you said about the fact it's not exactly the same thing, the two-step analysis of the court, interference, establishing interference, and then a justification possibility, in the sense that there is still a justification possibility for the state. But isn't that the same as working with similar? It's maybe not identical, so it may not be an actual presumption of a violation, but if the court establishes an interference, then the ball does go into the camp of the state, and it's the state that needs to justify, right? So it is a similar thing as with the burden of proof. Prima facie case is for the claimant, then once it is established, the burden of proof goes to the state. Same when it's an interference, when there is the court is persuaded that there is an interference, then the ball is in the camp of the state. So it's the same as with the burden of proof. It's also not, the prima facie case is not saying that there is discrimination. It's also there. It's another, the state still has an opportunity to counter. But it's the two-step process is actually quite similar. The ball goes from the camp of the claimant to the camp and the duty and the obligation of the state. So third point, well,
Kristin, I will have to, I'm so sorry, I will have to interrupt you here, but please.
One
all right,
sentence,
sure.
One sentence.
Final
and
sentence.
It's easy because I'm actually going to the next presentations. The whole point that you were saying about the evidentiary confusion, I'm not the only one that makes that point. I think that is also the people that are speaking behind me are saying that. So I'm gladly leaving that to them, and then we can pick it up in the bigger conversation. And all the rest we'll deal later. Okay, I'll just leave it for later. But I would
thank you so much. Please keep your thoughts. We want to hear them at the end of this discussion. It's really interesting. Over to our next speaker. It's my great pleasure to invite Joseph Finnerty from Hertie School to present his article on When is the State's Hidden Agenda Proven? The Role of the Merabishvili Three-Legged Evidentiary Test in the Article 18 Strasbourg case law. And the discussant will be Dr. Corina Heri from the University of Zurich. Over to you, Joe.
Perfect. Many thanks, Nele, for giving me the floor. I know that you messed up my surname there, Finnerty. It's fair snow in Irish.
Finnerty, sorry, I was busy having to practice Kanstantsin's last name, so sorry. Skip yours.
That's very fair. That's very fair. And many thanks, of course, to Vassilis and Kanstantsin and Marie. Being a not only an early career academic, but also a fairly early PhD, I mean, publication is a very daunting process, and the support mechanisms that the three of these editors put in place for me were greatly appreciated, and I think that deserved a special mention. And also, of course, thank you to all the participants, and in particular, Corina for taking time out of her incredibly busy schedule. Not sure how many of you came across Corina, but I think she has the secret ability of time travel as well as teleportation. She's here, there, and everywhere. So many thanks, Corina, for taking the time to attend and comment today. I propose to make a couple of abstract observations before positing the infamous, or not so infamous anymore, but previously infamous Article 18 in this webinar. And I think to start with, I think I'd push us to think about how we define and consider an evidentiary regime, and I make a stab at this in my article, and I put myself to the staunch critique of the dissectors in the call, where I propose the definition of evidentiary regime as a constellation of various requirements and notions which guide the court's approach to evidence. Now, I'd add a couple of provisos to that, having heard these previous presentations, two in particular. I think the first is that the regimes really do change. Different provisions have different regimes. So I think we find the way these different components are playing out. Sometimes there's cross-cutting components when we talk about the BRD standard, the burden, the beyond reasonable doubt standard, that cross-cuts across all these different provision regimes. But its application really does sometimes change depending on the provision. And I think, following on from Marie here, and I think this is present in the Article 18 case law as well, is sometimes the regime change within the provision. Now, Marie and Vassilis kind of pushed at this a little bit more about the effect within Article 3, and when we're talking about evidence when there's an assessment of inhuman and degrading treatment, and we're talking about evidence when there's torture. Now, of course, there's a different legal threshold there and it impacts it, but I think we can say that maybe it also impacts the way the court looks at evidence in different cases. And I think the observation I'd like to put forward for Article 18, which I'll come into here, is that I think also the respondent state makes a huge difference in the context of the evidentiary regime. And this is something that I think the dissectors will have plenty to say on and be much more offer much more insights than I am capable of. So why Article 18 as effectively? I mean, I think if we look at this fantastic special issue as a whole, we see that we've effectively got 4 very excellent case studies. And my case study that I put forward is Article 18, looking at the court's regime for evidence through that lens and that particular set of case law. Now, those who are usually, when I first started my PhD research, it was still shrouded in mystery, but due to many hardworking and fantastic and insightful academics, it's not so shrouded in mystery now. But just very quickly, for those on the call who aren't familiar with the provision, Article 18 concerns restrictions on human rights. So the provision itself provides that the restrictions permitted under this convention shall not be applied for any purpose other than for which they have been prescribed. So in short, it effectively prohibits states utilizing restrictions provided for in the convention for ulterior purposes, for basically pursuing a hidden agenda. Now, Article 18 was very much a provision that was stuck on the back shelf of the Strasbourg pantry for many years. And the first violation, the inaugural violation in 2004, concerned a Russian oligarch by the name of Dzehtsiarou, who was basically alleging that his persecution was motivated by the ulterior purpose of securing his media empire. And the court found such an allegation proven and a violation of Article 5, basically on the basis of a black and white document signed by the Russian Ministry of Communications, the Russian Minister of Communications, saying that in effect he would be released and his prosecution would be terminated should he relinquish his company to the ministry or agree to sell his company to the ministry. And there was a couple of similar cases where such sort of like the paper uses the court red-handed standard, and the court itself later labels that as incontrovertible and direct proof, if we want to talk about standards. To keep 18, there was a really rarely violated provision. Now, this all kind of changes. I mean, the paper goes along the line that Merabishvili, as a Grand Chamber judgment, permanently changed it, but it is worth mentioning as a side note, there are some very important Azerbaijani cases that really laid the groundwork for recognizing that such a standard wasn't really possible in practice, and really gave applicants a chance with particularly the recognition of the value of contextual evidence in Article 18 cases. So Merabishvili comes along. I mean, Merabishvili very quickly concerns the persecution of former Georgian Prime Minister Ivan Merabishvili. He was basically detained and asked various questions, and he alleged that his detention pursued the ulterior purpose of extracting information from him as regards to another prosecution of another individual. And this was in the backdrop of a very toxic political environment in Georgia at the time. Now, here the Grand Chamber took the opportunity to basically say, in short, in a very long 300-something paragraph judgment, Article 18 is pretty much unattainable to secure a violation. It's pretty much impractical, and it's not really attainable for applicants to secure a violation under the present approach put forward by the court, namely this incontrovertible and direct proof. And they say, well, we're just going to apply the usual standard of beyond reasonable doubt. I think I have to follow up with a general comment and caveat there that I made at the start, that I think the beyond reasonable doubt standard does really change depending on the provision you're talking about. And Article 18, this paper argues, continues to impose a relatively high provision, a standard of beyond reasonable doubt, gloss on beyond reasonable doubt when compared to other provisions. Now, I want to kind of highlight the three-legged test very quickly, and the where it comes from. This is one of the objects of the study within my paper. So how it's been imported into the Article 18 evidentiary regime, and the court's sort of problems with each of these. So the first thing that's required to be proved in terms of evidence, or sometimes in terms of evidence, as we'll come on to say, is this fundamental aspect of the case criterion. Now, Kristin will be very familiar with this, and she touches on this in her paper. This is a creation of the court's own on the court's own initiative under Article 14 in discrimination, and basically distinguishes instances where it would not or would consider it worthy to consider the Article 14 complaint in discrimination cases. So the court decided to import this, and does very little to explain why this is the reason, but my paper argues that this is where it comes from, looking at the citations within Merabishvili. So it's an internal importation. Now, what's not really clear from, I mean, two kind of problems arise in respect of the fundamental aspect of the case criterion. And the first is that it's not clear whether it requires an argument or evidence or both. So whether it is in fact an evidentiary leg, because in some cases it just simply makes its assessment as saying it's a fundamental aspect of the case, an immediate conclusion, moving on to the next step. And others, it does require some evidence to be pled by applicants. And the second is a conflation with other legs, and this happens in some notable case here is Sambunju and others against Turkey, which concerns a group of journalists, where it conflates the fundamental aspect of the case criterion with other criterion, specifically this identification of an ulterior purpose. So this is the second criterion, and here we see a lot of influence and comparative influence from domestic constitutional courts, as well as the Inter-American Court of Human Rights, and in particular, Merabishvili did on paper recognize the value of contextual evidence in determining the existence of an ulterior purpose. One very quick note here, because I appreciate I'm running a wee bit, I'm running towards the end of my time. I do try and make a distinction between narrow and broad contextual evidence in the paper, and I argue that these are effectively given different tiers of treatment. So the court is much more favorable to narrow contextual evidence, and by that I think it's very helpful for the practical lawyers in the room for us to start talking about what we actually mean by that. I mean contextual evidence which is very directly and proximate to the applicant's case. So this particular applicant has been questioned for a long period of time, or is questioned or given questions by the police which are unrelated to the crime which they've been detained in respect of. And broader contextual evidence is evidence which does not concern or isn't that proximate to the individual. So here I mean kind of broad changes in legislation, cranking down on civil society, changes in sort of the judiciary that may be arguably classified as court packing, etc. And the court starts to warm up to this kind of evidence, first in the Azeri cases, and then on paper recognizes their value explicitly in Merabishvili. And I argue that this really it's influenced largely from these domestic courts and the Inter-American Court. Now, still with the identification of the ulterior purpose criterion, there are massive problems. And I think the reference here to the Sambunju case again is fully deserved, where particularly where it really does apply a standard which is akin to incontrovertible and direct proof, and not really akin to its newly proclaimed application of beyond reasonable doubt, and effectively results in a higher standard of proof being reapplied in Article 18 cases. And then finally, the final leg, the final evidentiary leg, is
2 minutes, Joe.
2 minutes, thank you. The final evidentiary leg, which I discuss, is the predominance criterion. Now, the claim I make here is looking at the Article 18 case law exhaustively, although it's a criterion, it's never not been met. So in some cases, there is no need for the court to consider predominance. And what do we mean by predominance? We basically mean when there are a plurality, so multiple purposes found to exist behind a motivation. So we can all have multiple reasons we want to do something. What's important in the context of Article 18 is what's the driving force, what's the predominant purpose. And the court is yet to find an ulterior purpose exists and not find it be predominant. So on the basis of this, I do push back against the existing academic critique, which is largely focused on predominance. But I think it's important to underscore I don't entirely dismiss it, because there is still the theoretical risk that this predominance criterion effectively acts as a money laundering mechanism and allows clean purposes, legitimate purposes, to launder illegitimate purposes and avoid culpability under the convention. And I think, tying back just very quickly, I think Article 18 here is hugely important in terms of evidence, because the court is looking for something that's hidden and is dealing with states which are, to push back or link back to Vassilis' point, states that are acting in bad faith when they commit these violations. So here, in terms of normative proposals to fix these shortcomings that I identify, talk very briefly here. I think fundamental aspect of the case needs to be clarified urgently. And I think that also applies in the context of discrimination still as well, notwithstanding the efforts of scholars there. And I think contextual evidence has to really be recognized as crucial in the context of Article 18 cases. And this includes not only narrow contextual evidence, but also broad contextual evidence. And I think finally, in terms of predominance, going back there, I also think there's scope in Article 18 to discuss shifting the burden of proof, and that has been discussed extensively by Kristin, but we can all work out or foresee how that would work in the 18 context, particularly where there's been a violation and the courts expressed doubts or concluded that there was no legitimate aim under the qualified conjunctive right to which Article 18 applies with. And then finally, pivoting back to predominance there, I think the court should be more clear in what it means by predominance and the process which it utilizes to determine predominance. But thank you. I see Nele's camera's back on, so I'll shut up now.
Thank you so much, Joe Finnerty. And over to Dr. Corina Heri. It's a great pleasure to have you here as discussant with us. Handing right back to you.
Thank you so much. I hope you can all hear me. First of all, I just want to take this opportunity to say that I'm very happy to be here with so many familiar faces to mark the publication of this beautiful special issue. And I'd also like to thank Marie for the invitation to comment on Joe's paper today. As we just heard from Joe himself, this piece looks at evidentiary issues concerning Article 18 of the Convention. And Joe mentioned time travel. For me, this was an opportunity to travel back to some work that I did on Article 18 a few years ago, and to really be thrilled by the richness of the work that Joe and others are doing on this topic. So Article 18 was basically ignored for a long time. Like Joe said, we didn't get the first violation judgment until 2004, and even then it was nearly impossible to prove a violation. Things have changed, but from the beginning, this has been a provision that raises major evidentiary challenges. And Joe's piece really goes right to the heart of this. So he zooms in on the evidentiary regime of Article 18. He identifies the tension that these kinds of cases raise in a system that trusts domestic courts to establish the facts of a case. And he shows that the court's position here isn't easy. So these cases are hard to prove, they have political connotations, and considerations like that really defined the early case law. So in the early case law, as we heard, we didn't have a standard of proof beyond reasonable doubt. Instead, we had a higher standard for Article 18, where the court required, quote, incontrovertible and direct proof. So as Joe recognizes in the article, this nearly made it impossible to prove a violation of Article 18 until, that is, 2017, when the Grand Chamber addressed this. And in Marie-Bénedicte, it normalized the standard of proof for Article 18, or in other words, it applied the usual standard of beyond a reasonable doubt. Now, this language of normalization is something that I've also used in my own work. And when Merabishvili came out, that judgment was a significant improvement over the old impossible evidentiary regime that we had for Article 18. But Joe's piece and the rest of the special issue as well, but especially Joe's piece, made me rethink that language. If the beyond reasonable doubt standard is contested and the court tailors it in different cases and circumstances, then there's no monolithic standard of beyond reasonable doubt and no normal standard to adhere to. So I thank Joe for that. And as I was reading this piece, I found myself thinking, what's actually going on with Article 18 at the moment? So in Merabishvili, the Grand Chamber explicitly tackled the question of when evidence is good enough for the court, and that was a huge step in the right direction. But Joe's article sort of tempers enthusiasm over Merabishvili and what came after it, and he does that in important ways. So he shows that engagement doesn't necessarily guarantee coherence, and he argues that the three-step evidentiary regime that we have now is still a sui generis approach within the convention. Now, that's not necessarily a bad thing, but as Joe walks us through the 3 steps in the Merabishvili test, he shows us that this new evidentiary regime lacks clarity and coherence. That starts with the first step, as we heard, where applicants need to show that the Article 18 complaint is a fundamental aspect of the case. And Joe explains that the court doesn't have a standardized approach to evidence here. He notes that academic commentators, myself included, initially didn't consider the fundamental aspect criterion to be particularly problematic. We were busy focusing our criticism on the predominance test, which is the third step. And so initially, the fundamental aspect criterion just seemed like a way to ensure that Article 18 wouldn't apply to every case that lacked a legitimate justification. But since then, and as Joe shows, the court's been anything but consistent on this point. And he succeeds in convincing us that we shouldn't pack too much material consideration into this aspect. I'd say this is maybe about remembering that Article 18 is a separate wrong from a violation of the co-invoked article, and making sure that it's actually possible to invoke it. At the same time, I'm also left curious about how this relates to topics that are discussed in other pieces in the special issue. So about how close the court gets to no need to examine or no prima facie case type language without ever using it. And for the second step of the test, which is about proving an ulterior purpose, as Joe said, states no longer need to be caught red-handed because the court now admits contextual evidence. And that sounds pretty good. But Joe's piece shows us that the court takes diverging approaches to contextual evidence. And as a result, he argues that the standard of proof is higher in many cases than it would seem. He points out that the court still seems to want evidence of a manifest irregularity. And that's evocative of the very first Article 18 violation finding, which Joe mentioned, the Kaczynski versus Russia case, where there was a black on white document signed by the applicant and the Russian communications minister that basically said, you won't be prosecuted if you sell us your media company. Now, Joe and I understand Kaczynski a little bit differently. He notes in the article that the court might have already been implicitly shifting the burden of proof to the government in that case because it noted that the government didn't refute the applicant's evidence. And I don't quite see that in the same way. So there's a difference between noting that evidence wasn't disputed and shifting the burden of proof. But that caveat aside, I agree with Joe that the break that Merabishvili brought about was less clean than it could have been. And his piece is admirably clear in pointing that out. I think this could be another legacy of the early Article 18 case law and its preoccupation with not immunizing anyone, including those in high positions of power, from criminal prosecution. So an idea that the standard of proof should err towards being too high rather than too low. And that brings me to the third and probably most discussed aspect of the Merabishvili test, the predominance of purpose. When the judgment first came out, the Merabishvili judgment, a lot of analyses focused on this. So on this idea about there being a chief or main purpose of a restriction. And initially this was often understood kind of like a pie chart where everything was okay if the pie is at least half legitimate. In practice, though, this didn't lead to clear standards about how to establish the size of the different pieces of the pie. The court has also linked predominance to the reprehensibility of motives. I'd argue that reprehensibility is one of the factors the court uses here for establishing which motive predominated, but it's still not really clear what goes on here, how you prove reprehensibility. And Joe shows us that the court generally just avoids the question of how to tell which interest predominates. So Joe's piece left me with a sense that there's still something exceptional and ad hoc to these cases, and that we still don't have rules that can be generalized consistently. There also appear to be some implicit assumptions at play about what should and shouldn't constitute an Article 18 violation. And I'd say these assumptions are probably a legacy of the pre-Merabishvili ideas about Article 18. And we may need to re-examine the idea that Article 18 cases are the very rare exception and that we'll know them when we see them. But in any case, as we see more of these cases and different kinds of cases, unprincipled decision-making will continue to get more obvious. Now, one key takeaway from Joe's piece is that we can't look away from evidentiary issues. Designing a special test can't exempt the court from making coherent and generalizable rules on evidence and proof. But we also see that the evidentiary issues are still really the core problems around the application of Article 18. And by analyzing that, Joe's piece really highlights the fact that evidentiary regimes shape the application of the Convention. That makes them key to ensuring that rights are practical and effective. It also makes them key to ensuring that judgments are based on coherent and legal reasoning. That brings me to the end of my comments, and all that's left to say is that it's been a real pleasure to engage with this piece and with this special issue, and that I look forward to our further discussions. Thank you.
Thank you so much, Corina. Joe, would you like to respond in about 3 or 4 minutes? If you could unmute, thanks.
Thank you very much, Corina, for taking the time once again, and thank you for your comments. I think I agree with you. Merabishvili, I don't think the court really fully understood what it was doing with Article 18 when Merabishvili came out. And I think when we go back to this discussion about different evidentiary regimes for different provisions under the Convention, Article 18 got this previous incontrovertible and direct proof because of the stigma that was attached to the violation. I do honestly think that. And I think it moved away from this stigma quickly, and now I think it's starting to get cold feet. And this really does explain the incoherence and lack of clarity, which ultimately comes from different views within the Strasbourg bench. Now, the reason for this is because what we've started to realize post-Merabishvili, not because of Merabishvili, actually because of an Azeri case and an Azerbaijani case, Article 18 has huge consequences in the context of the Committee of Ministers. Now, again, this is a big claim, and Kanstantsin might jump in here in the comments, but I am of the view, and I remain of the view, that as things stand, the triggering of infringement proceedings under Article 46 has an implicit requirement of an Article 18 violation. That's my position. And I think because of this kind of consequential reality of Article 18, it's resulted in this kind of put the brakes on, should we really be normalizing Article 18? And then this has resulted in us maybe thinking, oh no, maybe we should put Article 18 back at the back of the pantry shelf cupboard. And then I think I just absolutely agree with all three of your succinct summaries of the three-legged tests and the different views that you have. And I think predominance is very interesting because everybody was concerned with it. But I think it may still prove to be a problem in the future. And the reason for that is because if we view the three-legged tests as hurdles, and me and Marie had a back and forth on this quite a bit, they were in an earlier draft articulated as hurdles, but that proved to challenge the clarity of my own paper and wording. But if we go back to using this analogy, the first two hurdles are very high: fundamental aspect of the case and establishing an ulterior purpose are very high, both in terms of evidence and in terms of legal persuasiveness of the arguments of the substance of the provisions. While predominance is very much still in the court's reasoning, in my view, a bit of an afterthought, because the applicants have done an excellent job in establishing the first two criteria, and also importantly establishing a violation of the conjunctive right. I mean, we can say in Merabishvili they didn't find a violation of the conjunctive right if we're going to be very specific in the 5.1c element there, but in all other cases it's always been the conjunctive right has been violated. So I think that's hugely important to consider as well. And Nele's camera is back on, so I know my time is up, but thank you once again.
I hate to be the role of cutting people off, but at the same time, we have a very exciting presentation from our last author, certainly not least author, Dr. Grazyna Baranowska, Heri School, with the title Exposing Covert Border Enforcement, Why Failing to Shift the Burden of Proof in Pushback Cases is Wrong. And again, thank you so much, Corina, as well, for your comments. Over to you, Grazyna.
Thank you, Nele, and thank you to the whole DISSECT team for having me here and for organizing. Let me try to share my screen. So, could you just let me know, Nele, whether you see my screen?
Yes, perfectly.
Okay, perfect. So thank you very much to the DISSECT team for organizing that and for everyone to sticking with us until 4. It has been quite some time. It's also a difficult position to be the last presenter in such an online webinar, but it's also a good position as I can connect a bit of what my paper is about with the papers before, and also show in that sense the perspective how this whole special issue really speaks to the same things and partially also makes very similar arguments. So the title of my paper is Exposing Covert Border Enforcement, Why Failing to Shift the Burden of Proof in Pushback Cases is Wrong. And the paper is part of my Marie Curie project, which is on missing migrants. And I look for the project, I can bring my earlier work on missing persons and disappeared persons into migration, and particular in violations that are happening at European Union borders. And as we do know, pushbacks lead to missing migrants. So this is kind of to situate this paper in my broader project and research. So the main argument that this paper is making is that the court expects applicants to in covert border enforcement cases to provide strong evidence, which is then labeled as prima facie evidence. And I argue that the burden of proof should be shifted in the same way as in enforced disappearance cases, as the position of the victims and the availability of evidence is strikingly similar in those two cases. And my presentation, while I will not go over all sections, it's structured exactly in the same way as the paper. So I will say something about all 5 of the sections. So starting with some general remarks, I define covert border enforcement practices as those practices in which states effectively prevent people from entering their territory while denying that such practices are taking place. And as I will explain a bit later, this can take various forms. But this is kind of at the core of what I am looking at in this article. And because those events are covered, they're more likely to result in other human rights violations, and that will often be ill treatment or even torture. And because they're covered, evidence is a huge challenge. So showing that they indeed have happened is extremely difficult, both in domestic and international proceedings. And the article is based on my previous research on enforced disappearance case law, which is mostly revealed in some of the chapters of this book. And then I did an analysis of covert border enforcement case law, and for that I looked into Article 4, Protocol 4 judgments, and added other relevant judgments, particularly relating to Article 3.
So now the core of the argument, that is, what is the burden of proof shift? So when does this shift? And we have heard about that a bit before. The court shifts the burden of proof from the applicant to the state when there's acute differential access to the information, acute difference in access to information, which advantages the state and leaves the applicant without evidence. And actually, this shifting of the burden of proof has been introduced in the case law on enforced disappearances. They have been a catalyst of change. And to shift the burden of proof, the court has found, first, the applicant need to make a prima facie case. That means that it's really fundamental which evidence is considered to be a prima facie, because then the burden of proof is shifted to the state. And in enforced disappearance cases, this has been found to be that this can be done based on circumstantial evidence, and then the burden of proof shifts to the state. There are also other ways by other human rights courts to shift the burden of proof that are not used by the European Court of Human Rights. And the most important one is the systemic patterns of violations by the Inter-American Court of Human Rights. And I've argued earlier that it would be good to use that with regard to enforced disappearances. And that also holds true for migration cases and pushback cases that I talk about now. But this is not a construct that the court has adopted for shifting the burden of proof. So what are the disagreements about covered border enforcement practices in the court? So I grouped the contestations in 3 different groups. So firstly, sometimes the states are arguing that the events in question did not happen at all. So for that, I give the example of MH and other versus Croatia, where a family crossed from Serbia into Croatia was pushed back, and while in Serbia, 300 meters from the borders, one of the children was killed by a train. And Croatia argued that they never crossed into Croatia. So that was kind of the disagreement about the events. Then the second group are when the state contests not that the events have happened, but that the applicants were involved in those events. And here an example is ND and NT versus Spain, in which a larger group of persons crossed a wall into Spain from Morocco and was pushed back. And Spain argued, yes, those events have happened, but the applicants did not take part in it and do not have evidence to prove that. And indeed, as Spain did not identify individually those persons or did not register them, it was extremely difficult for them to prove that they took part in those events. And then the third group of situations are when applicants had applied for asylum. And in this sense, in this group of cases, which might be one of the biggest group of cases, the states are recognizing that the persons are at the border, but that they have not asked for asylum. So this is what the contestation is about. So you can see that there are differences also in what is contested. So what are the similarities and differences with enforced disappearance cases, which is important to see as I am asking for applying the same standards. So in both cases, the facts underlying the case are in dispute, and this takes different forms in both enforced disappearances and border cases. Then there's a lack of documentation, and importantly, there should be an official record of all detentions and of all expulsions. So there should be documentation that is either not done at all or is not provided to the applicants and to European Court of Human Rights. And then there's a clear power asymmetry between the parties concerning access to the documents and responsibility for that I argue can only be addressed through by the European Court of Human Rights through assessing evidence. Going into the differences, the case law on enforced disappearances has been established by the court through based on judgments against Turkey concerning the southeast of Turkey, Kurdish cases, and Russia concerning Chechnya. So there are 2 very non-cooperative states that are within a huge internal conflict. At the same time, the court has never said that it's only shifting the burden of proof because the states are non-cooperative or because they are within an internal conflict. And the court has actually applied this construct also to other enforced disappearance cases that did not take place in an internal conflict. So in that sense, I don't think that the overall context should be a reason to differentiate between those two groups of cases. Then another difference is access to digital evidence. And it is true that now it's easier to make pictures, take videos, and so on. However, not so much at the border, where very often it's forbidden or made impossible. And also in those cases in the end of the 90s and beginning of 2000s, very often pictures and videos were actually submitted to the court or in domestic proceedings, if applicable. So in that sense, while I acknowledge that there are differences, I don't think they're big enough to explain a difference in approach. So how does the court shift the burden of proof in covert border enforcement cases? So as I said in the beginning, it actually labels evidence that I argue is more than prima facie as prima facie evidence. And I use the term in my paper, sufficient evidence. Kristin used it a bit different. She said full evidence, but I think we are aiming at the same thing. And here, one of the interesting things that I found in one of the judgments, again, MH and other versus Croatia, is one of the dissenting opinions. A judge said that this was not prima facie evidence. And he used it for an entirely different reason than I did, but it really kind of shows that there is discussions about that as well. So as far as what evidence provided was found by the court to be sufficient to be leading to a shifting of the burden of proof. In enforced disappearance cases, it was, for example, testimonies of eyewitnesses, or that the disappearances have occurred in an area within the exclusive control of the state. At the same time, MH and other versus Croatia, on the one pushback that was found to be substantiated, there were domestic proceedings, and the court has found that they have never verified police allegations, and as such there were huge mistakes in that. And in that sense, and also as Judge Wojtyłek has argued, that was sufficient proof and not prima facie proof leading to changing shifting the burden of proof. And even more importantly for me, the applicants have argued that 3 pushbacks took place, but the court did not recognize the other 2 pushbacks. It said they were not substantiated, only this one where there was prima facie evidence. So I'm arguing that there's a higher threshold of covered border enforcement cases, and there could be 3 reasons. There could also, of course, be more, but I talk a bit in my paper about 3 possible reasons. So there's clearly the court's differential attitude towards state border practices, and here in this digital room we have scholars that have already made that argument very broadly and importantly. Then the second argument could be the assessment of cooperativeness or non-cooperativeness with the European Court of Human Rights. And that argument reminded me, I thought about that argument a lot during the discussion between Marie and Vassilis on the double standards in the Western democracies. So kind of what applying the burden of proof to Russia and Turkey is different than shifting the burden of proof with regard to Western democracies, EU countries, and that are usually cooperating with the court. However, here I would have a number of problems assessing that, meaning mainly that it's not clear what actually is a cooperative state and what is not. And lastly, the European Court of Human Rights violations involved. And here Joe already mentioned as well that provisions are relevant for how the court deals with, in his paper he talked about beyond reasonable doubt, but this holds true also for other other tools, and here with the shifting of the burden of proof. And if that is the reason why the court is changing that could be the case, then the court should apply, at least shift the burden of proof in those covert border enforcement cases that relate to violations of Article 2 and 3 and differentiate them from other covert border enforcement cases. But the court does not do it. In MH and other versus Croatia, it was really an Article 2 case. So it was exactly kind of the same magnitude and seriousness as we have with disappearances. And I actually, when I looked at the guidance on parameters introduced by Kristin, it also made me think of that. You will see a lot of analogies here and show that different lenses you take at shifting the burden of proof, you still see the same problems arising. So concluding, my very last comment is that one of the things that the research showed is that the court is not sufficiently taking into account the conduct of the state. So when the state provides the court with false information and has a proven practice of the alleged act, and this is what Croatia has done in MH and other versus Croatia, in my opinion, this should be assessed as prima facie evidence and shift the burden of proof to the state. So I am arguing, reading those cases, that there is not sufficient account of conduct of the state. And Nele, I see you again. Thank you for keeping time, and I'm done with my presentation. Thank you.
Thank you so much, Grazyna. Pretty much perfectly on time. I appreciate that. And now over for our last discussant, Professor Violeta Moreno-Lax. It's a delight to see you here. You're from Queen Mary University of London and University of Barcelona, and I invite you to provide your comments on Grazyna's paper. Thank you so much.
Thank you. Thank you very much. Can you hear me well? All right, thank you. So thanks a lot for having me here, Nele, and to the other organizers to comment on Grazyna's paper. First of all, I would like to congratulate Marie for the work on the DISSECT project and for putting together this work.
You're muted.
Violeta, we heard you until
Sorry.
you were giving thanks to me.
Right, okay, so
and then you disappeared.
Can you hear me now? Yeah, okay. Right, because I have I have written up my comments. That's why I was like switching between screens in an attempt to keep time as effectively as Grazyna. Let me try again. So I was just thanking you, Marie, for the DISSECT project and for the special issue. Evidentiary questions and burden of proof issues are not your sort of, I don't know, standard themes in human rights literature, probably because they are considered to be dry and unattractive when compared to substantive issues. So I think there is huge potential for the special issue to make a very big contribution and fill an important gap. So congratulations to you and to the entire team and those involved. Now coming to Grazyna's paper, there are the two key points that she has presented today and that the paper make, and that I think will constitute an immediate and very valuable contribution to the analysis of pushbacks and the controversies surrounding what she has called the covert border enforcement practices of states. I think this effort at defining pushbacks as covert border enforcement practices is actually a very good step forward in that direction, and a key contribution to the conceptualization of pushbacks as directly suspect and I think directly ill-aligned with the European Convention standards. So in line with this definition, I wonder whether collective expulsion should always be characterized as a form of covert border enforcement, and in such case, whether they should entail by default the reversal of the burden of proof that Grazyna is propounding in her paper, particularly when presented with a prima facie case of their existence, like the situation is in Greece, for instance, with the Evros River pushbacks and the situation in the agency. That would be great. It would really tick all the boxes of the proposals that she's making in the paper. And I was wondering whether that would be a more economical way of asking the court to take a pro-human rights stance with less of a burden in terms of defining what prima facie evidence means and when it should be considered to be submitted. The second contribution, I think, that the paper by Grazyna makes is the fact that these practices, being covert and unacknowledged and semi-secret, are similar to enforced disappearances. And so this emphasis on secrecy and non-acknowledgement of these practices allows for a comparison between the two sets of case law and facilitates the discussion on the different evidentiary standards that apply in the two situations. And indeed, the paper assesses how the court deals with evidence in pushback cases as compared to enforced disappearances on account of the similar stances taken by the defendant states in each case, who tend to either deny that the facts have occurred, to deny that they have involved the applicants, or to deny key elements of their account, and sometimes even using false or fabricated proof. So, for example, in the case of MA versus Lithuania that Grazyna has commented on, states deny that the applicants have applied for asylum, even though they do present a record, as cursory as it may be, of that precise act, and they include pictures of train tickets and a number of other elements that should have led the court, or could have led the court, to conclude that there was sufficient evidence of an asylum claim. And in the dissenting opinion attached to that case, we see that this is considered not to be sufficient in terms of prima facie or sufficient on the whole proof for the court to consider that there has been a violation. And what strikes me from this, and I would like maybe Grazyna to elaborate on this, is that the court appears to be attaching significance to the fact that there was an asylum application. So beyond the points in relation to the pushback itself, the court appears to be attaching importance to the fact that there was an application for asylum, that the applicant submitted, and that the state is denying. And I wonder whether this should be the case, because Article 3 and Article 4, Protocol 4, so the prohibition of ill treatment and the prohibition of collective expulsion, are applicable on a universal basis, right? They apply to everyone, regardless of circumstances and regardless of status. So it shouldn't matter whether the migrants have submitted or not an application for asylum. So I was wondering whether, by putting the emphasis on this point, we will see in future case law the emergence of differential scopes of protection for the two groups, which I think would be highly problematic and very undesirable. But I wonder whether this is the direction of travel, and what do you think, Grazyna, should we do of such an obiter dictum in covert enforcement, border enforcement cases like this one? Now, despite the similarities between the two groups of cases, the enforced disappearance cases and the pushback cases, Grazyna's analysis of the case law displays a different position taken by the court in the pushback cases, where a higher threshold of evidence, it is said, is requested of applicants in this situation. In some instances, we might actually reach the beyond reasonable proof standard that Marie and the entire special issue deals with, and I think this is again very problematic, before allowing for the shift of the burden of proof to the state. And this happens irrespective of labeling the evidence as prima facie. So the fact, and this is the other problematic point that I would like Grazyna to elaborate upon, the fact that the court never defines what prima facie evidence is, or at which point it may be considered as having been provided, is, I think, what permits a differential approach. And even the emergence of a double standard, right, that tends to disfavor the migrant applicants concerned in pushback cases. So my question would be, how should prima facie be defined? And is prima facie the same as the arguable claim standard that the court employs in admissibility decisions? And if not, should it be, or should they be kept separate and lead to different standards? Now, given the striking similarities between the two sets of cases, the enforced disappearance cases and the covert border enforcement cases, Grazyna claims that the two should lead to similar results, and the treatment of evidentiary rules and the distribution of burdens, and the point at which the onus should shift from the applicants to the defendant state in a commensurable way. And this is particularly on account of the fact that direct evidence of the practices concerned are in the hands of the state. The applicants may only ever have access to circumstantial proof, witness accounts, and maybe reports from NGOs and international organizations, but that's it. They are not going to have the hard evidence that would demonstrate that the facts occurred and in the way that they are claiming. And the power asymmetry is so strong that that alone should lead to the shift of the burden of proof that Grazyna is propounding. And I wonder, however, what should in this context count as direct evidence, particularly in the pushback cases, considering that the whole point of these cases is precisely to leave no trace, no documentary proof, and no record of what happened. So should states be able to rely on their own wrongdoing to avoid scrutiny and condemnation by the court, or should the court adopt a sort of stopple approach and consider such practices as precisely part of the very violation being assessed, and then act in consequence and redistribute the burden of proof, or even not treat that as a burden of proof problem, but part of the merits assessment? So I don't know if your assessment, Grazyna, would change if that was the alternative approach adopted in these scenarios. Dissenting opinions in several pushback cases, and I'm coming back again to MA versus Lithuania, seem to point in the opposite direction. So I don't know if we can harbor a lot of hope in this regard that the court will adopt a stopple approach in these situations, claiming that high standards of proof should actually apply in pushback scenarios, because otherwise states would be impeded from effectively controlling their borders. This is very controversial, and I think is a non-legal argument that the dissenting judge is making in that case, but is one that I think is very prevalent in the discourse and in the debate at the political level, and it appears that those non-legal political arguments are infiltrating not only the legal argumentation put forward by the different parties in these cases, but it's also permeating the court reasoning itself to its own peril, I would say. Now, why the approach in covert border enforcement cases is not the same as in enforced disappearance cases is intriguing. And Grazyna has explored three potential reasons, right? The first is the overall differential attitude of the Strasbourg court to states in migration cases, based on the principle that states have a right to control access to their territories, and using that as a starting point in the assessment of whether there have been any human rights violations concerning the migrants at stake. And I suppose this ties in with Marie's Strasbourg reversal argument that she has made in her work, whereby rather than rights constituting the starting place for the inquiry, it is rather the power of the state to exclude migrants, which is used as the main reference point. I wonder whether reversing the reversal might be the answer in this situation. The second reason that Grazyna identifies is the non-cooperation of states with the court, which is routine in enforced disappearances scenarios, but it's not considered such in pushback cases, although this is actually without a basis in current realities if we look at what happens on the ground, right? And there is a very powerful illustration in the Aegean and in the Evros River Greek pushback cases that have, by the way, never yet been condemned by the court, partly because of evidentiary obstacles. The third reason that Grazyna advances is the gravity of the violations involved, which in enforced disappearances engage Articles 2 and 3, whereas in pushback cases, Article 2 tends not to be invoked, although it could be considered to be encompassed within Article 3 and Article 4, Protocol 4 claims, since, as Grazyna, you say, risks of refoulement have generally translated into loss of life. So the compatibility in terms of gravity of the violations at stake is very much a thing. And this leads me to two additional reasons, maybe that.
Sorry, Violeta, could you start to wrap up?
I'm wrapping up.
Great.
I just have two more points and I close. So I have two more reasons that I would like Grazyna to consider. So perhaps the main reason for me would be the raison de cour that Marie has put forward earlier. Maybe what the untold reason why the difference in between these two sets of scenarios is the fear of the court of a backlash if it relaxes evidentiary rules in pushback cases. In fact, the European Commission has ignored all of the precedents that are commented by Grazyna in the paper. And rather than use the experience gathered in Poland, Lithuania, Latvia, Croatia, Italy, and Greece with the hotspot approach and the pushback cases as a basis for the reform of the EU migration and asylum system, what we see is the new pact instruments that have been agreed in December, actually codifying many of the covert border enforcement practices condemned already in the available case law by the court and providing legal cover to their continued use in practice. So I think fears of a backlash or the direct ignorance of the precedents of the court might be a very powerful reason in this situation. And with this, I close. The final point that I wanted to make is the fact that enforced disappearance cases were addressed against Russia and Turkey in comparison with the more important EU member states responding to accusations of human rights violations in pushback cases may be the decisive factor. Like the double standard emerged in the Greek and Irish torture cases that we commented on before, a similar pattern can be seen in this field. The approach of the court, I think, tends to be more deferential to EU democracies than to other less important members or former members of the Council of Europe. And I think this is a final political element that has been lurking in the paper, but has not made it to the forefront. So thank you very much, Grazyna, and thank you all for your attention.
Thank you so much for your very comprehensive comments, Violeta. Grazyna, I will give you 2 minutes to respond, and then, of course, you can pick up in the general Q&A afterwards. Thank you so much.
So thank you very much, Violeta. It was super rich, and I took notes, and I will keep thinking about it. So I will only really jump on a couple of questions. So are pushbacks, for me, are collective expulsion always covered border enforcements? Most of the time, but they're not always covered. So in those kind of domestically legalized pushbacks in Poland, they would not. So, but in generally, Evros is for me the prime example. Do we need a definition of prima facie? Yes, I think we do. And we might even need specifically one for border violence. I do think that it is different. Kristin talked about prima facie in discrimination cases, and I felt a lot of resonance and importance there, but I do think there are some specificities that would need to be made there. But Kristin, if you would like to jump in on that in the Q&A, maybe that would be also interesting to hear. Should there be a estoppel approach? I think that would be great. And I agree that there are political reasons why this will not happen. And you're right, I had that thought in my mind and I did not make it very clear in the paper. One thing I tried to do is to keep repeating that Turkey and Russia were said they can do it while there was a war, while European democracies were said they do not have to do it just because they're protecting the border. And to be clear, an internal conflict is much more difficult for a state than controlling borders. So it's really fascinating to see how a human rights court is giving bigger expectations to a state that has an internal war than to a state that it's just trying to protect its external borders. So this was the comparison I was trying to make in my paper, but I do know that I did not say that clear out. So maybe it's missing and it should be written there as one of the possible reasons.
Thank you so much to the both of you. And now I will pass the microphone to my very dear colleague, Anne-Katrin Speck, who I would say, along with Marie, is the expert on evidence before the European Court of Human Rights. So I'm really curious to hear their takeaways and conclusions that they draw from this whole fantastic panel so far. So Anna, if you'd like to take the stage, over to you.
Thank you very much, Nele and Marie as well, for giving me the chance to say a few words at the end of, yes, indeed, what was a truly stimulating and thought-provoking event. I must say that I really enjoyed reading all of the contributions by the authors and listening to the authors as well. And I trust that the special issue will be a reference point for academics and practitioners alike, as well as for court insiders, in fact. Now, the presentations we've heard were frankly too insightful and the discussions too rich for me to try and do them justice by synthesizing them or attempting to do so. So what I'd like to do instead in the allocated time is to selectively pick a few of the transversal themes that we have come across. And in doing so, I'll also draw on my own research, which explores the various factors that shape and condition the Strasbourg Court's evidentiary practice. This comprised me doing 50 interviews with former and current Strasbourg Court judges and registry officials, litigators as well, and a 5-month study visit at the court, which provided invaluable insights into sort of the nitty-gritty operation of the evidentiary system. Now, the first point I would like to briefly touch upon concerns evidence of systemic problems or patterns of violations. We've heard that covert practices and motives as well, be they linked to discrimination or ulterior motives in restricting convention rights, are extremely difficult to prove. And in this connection, one issue that connects the papers from Kristin and Joe is the extent to which the court itself is creating evidence, if you will, by establishing a series of cases, often concerning the same contracting state, that repeated violations follow a specific pattern. Now, that practice is not entirely new. That in the Chechen enforced disappearance cases that Grazyna mentioned, the court established, for instance, that on the basis of its own repeat violation findings, that unacknowledged detention by unidentified servicemen is life-threatening in the Chechen context. As Grazyna stressed, it hasn't gone so far as to accept the systemic patterns alone as sufficient prima facie evidence. But still, the question to me is, if the court is really well set up to discern such patterns of violations, its logic of taking one case at a time and limiting its examination to the specific facts of the case, or even to parts of the case in the interest of judicial economy, as Corina has alluded to, would appear to hinder rather than allow for such a holistic view, which in turn then doesn't really alleviate the evidentiary burden on applicants, of course. And against this backdrop, creating these links between similar violation findings, which the court is to a certain extent doing in adopting a project-based approach to certain case clusters, seems like a really important tool to mitigate the disadvantageous position of applicants, whose success really depends on proving that the treatment they suffered formed part of a wider practice. Now, another recurring theme was the lack of conceptual clarity surrounding key evidentiary notions and the ensuing inconsistency in their application. Marie's identification of a virtuous and vicious operation of the BRD standard exemplified this, which found support in Joe and Corina's remarks that there is no monolithic notion of BRD. And we also heard the various engagements with the prima facie standard of proof. And it's quite remarkable, isn't it, that Grazyna, Joe, and Kristin's studies, independently from one another and concerning 3 very distinct areas of the court's case law, revealed that this label, that the court labels evidence as prima facie, that is actually reaching a much higher threshold. And I appreciated that the authors denounced a misuse of this key term and that they pointed us to the real consequences that this, say, terminological fuzziness or vagueness can have. Here, the risk of a creeping elevation of the evidentiary threshold that applicants must meet before a presumption arises that the state will then have to rebut. And I would add that this risk is really not purely hypothetical. We can already see that a lack of terminological and conceptual clarity produces a really fertile breeding ground for mistakes, frankly. Several of my interlocutors at the court recalled instances where draft judgments, especially concerning Articles 2, 3, and 14, essentially put the full evidentiary burden on the applicant to reach the BRD standard, rather than, as we heard, being prepared to shift the burden of proof, the court accepting that proof may follow from unrebutted presumptions of fact, and so on. And while some mistakes of these kinds will no doubt be avoided by internal quality checking routes, some drafts featuring an erroneous application of these key evidentiary principles will likely fall through the cracks and find their way into the court's case law, thus potentially becoming of precedential value. And this is a cause for concern. Now, permit me to stay on this topic of evidentiary confusion, as Marie calls it in the editorial to the special issue, for one more minute. To extrapolate a little bit from the discussion this afternoon, I have found in my own research that this is in part due to a lack of a common conceptual framework and agreement on the theoretical underpinnings of the proclaimed evidentiary principles. People in Strasbourg speak in strikingly different ways about not only what their evidentiary practice should be, but also what it actually is. There doesn't even seem to be agreement on what precisely the fundamental notion of beyond reasonable doubt means or connotes. When asked to elucidate the autonomous meaning of the BRD standard in Strasbourg, judges and registry officials tended to associate it with lower evidentiary standards, such as balance of probabilities or preponderance of evidence. And one judge made this point quite succinctly when he said, and I quote here, "The question isn't what happened. The question is, was there a violation?" And we find that on whatever standard you may want to apply. We're finding it on preponderance of evidence or a balance of probabilities, whatever you want to call it. And we don't ever label it that way. So this is quite striking if you really think about the origin and how far back the BRD standard really dates. And to me, the fact that there is no single working approach feeds this risk of inconsistency that we've talked about. And it also makes the court's evidentiary practice susceptible to all sorts of pressures, including pressures linked to attacks on its legitimacy, as we just heard again from Violeta, who underscored the apparent fear of backlash. That brings me to the final cross-cutting theme that I want to pull out, and which pertains to the sense conveyed by all the speakers that the court in its evidentiary practice is wary not to open itself up to too much criticism. Criticism, mind you, from states. The contributions reveal that we're dealing with an institution that's really acutely aware of the socio-political environment in which it operates. And we've actually seen this throughout the history of the court. It's arguably no coincidence that the BRD standard dates back to the early interstate cases. Marie pointed out that the political salience of the Irish case can hardly be overstated, because for the first time, an established Western European democracy stood accused of really large-scale serious human rights violations. And importantly, what we shouldn't forget is that this case also came at a time when, institutionally speaking, the court was under a constant threat of states withholding or withdrawing their consent to its jurisdiction. Because I should remind people that just like the right to individual petition before the European Commission, then still functioning, the jurisdiction of the court was actually an optional feature of the convention. So throughout the court's almost 65-year history, its evidentiary practice has very much been in constant flux. It's grown incrementally, and this is important, in response to changing challenges facing the court, from the need to build its reputation vis-a-vis reticent states, to the need to deal, as Grazyna has alluded to, with a surge of cases from Southeast Turkey and Chechnya involving large-scale human rights violations, and partly giving rise to a need to do fact-finding in situ. Essentially, the history of the court's evidentiary practice is one of adaptation and pragmatism. And Joe has alluded to changes that occur even within the evidentiary regimes under different provisions. But again, to me, it's precisely this flexible, adaptive, and reactive nature of the court's evidentiary practice that makes it susceptible to political pressure. The current climate in Europe foregrounds sovereignty and legitimizes a policy of turning away migrants. Okay, then you may well see that the Strasbourg Court's evidentiary practice is not designed in the most applicant-friendly way. The Council of Europe starts recognizing that there is a massive threat posed by shrinking civil spaces and attempts to stifle political opposition. Okay, then that might translate into a more lenient approach to evidence in its Article 18 case law. I am, of course, to a certain extent oversimplifying things, but the point remains that the court speaks to its constituents, both states and applicants, through the way it treats evidence. Legitimacy concerns can make it more prone to adopting a state-friendly approach. And in my own work, I refer to this as political appeasement through the evidentiary backdoor. Now, it wouldn't be fair to leave you with quite as bleak an outlook, I guess. I do believe that the court has developed the evidentiary tools, rules, principles, and practices necessary to help it achieve fair outcomes in cases where it has no chance but to act as an establisher of the facts. And while it's crucial that we call a spade and put the finger on problematic practices, it should also be acknowledged that the court is grappling with very real challenges. Fortunately, we've seen that, or I've seen that individual agency can go a very long way in securing positive outcomes or fair outcomes that take account of the disadvantaged position that applicants find themselves in. I've come across several examples, for instance, of registry lawyers going the extra mile to not have a case thrown out at the pre-admissibility stage just because it's sort of clumsily argued and not ideally substantiated. And likewise, registry officials have, in exceptional cases, successfully pushed for additional investigatory measures to be adopted or for additional evidence to be solicited and submitted. Admittedly, such proactivity is now institutionally discouraged in today's age of subsidiarity when case law pressures translate into this strive for ever-increasing efficiency. But yeah, that actually brings me to my final point, which struck me as somewhat of an omission from today's conversation. Isn't it striking, I was wondering, that in none of the case clusters examined by the authors of these contributions, we saw a court that leaves no stone unturned to elucidate the full factual context of the cases before it. In the pushback cases, the court contents itself largely with following the state's accounts. In the Article 18 case law, it prefers relying on narrow rather than broad contextual evidence. And in racial discrimination cases, it struggles to take a holistic view on structural problems. Even in the Irish case, even though that dates back a number of years, a number of decades, the court allowed the UK government to get away with concealing crucial facts, twice actually. I think it deserves highlighting then that the Strasbourg court is a reluctant fact finder. This goes beyond it just having de facto ceased fact-finding investigations in situ, and also encompasses fundamental divergences of assumptions about what the court's role should be. The dominant perception that I encountered in Strasbourg was that the court is not a truth-finding tribunal. This stemmed not only from a recognition of its epistemological constraints in knowing exactly what happened, given its geographic and temporal distance from the facts of a case. It also entails, and this is quite fascinating, a more principled position in accordance to which it is simply not the court's role to establish the truth. That rule, to many inside the court, is limited to ruling on the convention compliance of certain acts and omissions, full stop. And to reach that conclusion, the proponents of this view would assert the court doesn't even need to always know or always have the full picture of what happened. And I think these positions and the frictions in terms of prevailing self-perceptions in Strasbourg are important to bear in mind as we try and make sense of the court's evidentiary practice. It's complex, it's messy, and yeah, its full appreciation to me necessitates that we ask not only how the court approaches evidence, but why it does so. Let me conclude then by circling back to the contributions of this fantastic special issue. I'll offer 2 observations and one final, more normative thought. The first observation is this: if we have learned anything today, I would say that it is that evidence truly is at the heart of international human rights adjudication, even if the Strasbourg court feels most comfortable when it doesn't have to make its own assessment of the evidence before it. Secondly, and relatedly, we saw that evidentiary rules are not neutral. Their design and operation will either exacerbate or mitigate the power imbalances that are at the core of proceedings before international human rights courts. And this is what makes getting things right on evidence so crucially important if the court is to effectively fulfill its mandate to uphold the human rights standards emanating from the convention. And finally, my normative reflection, and I'm a bit hesitant at this stage to make any hard-edged recommendations, but to me, it certainly stood out today that the need for the need for the Strasbourg court to at least be more deliberate about its treatment of evidence. To my mind, that includes overcoming the apprehension I encountered among judges and registry officials of taking a deep dive into evidentiary matters and their theoretical underpinnings, and consolidating this conceptual framework guiding Strasbourg's evidentiary practice. I think that this special issue is an important step in that direction, and I can only reiterate my warm invitation to everyone to read it and congratulate the authors once more on their fascinating contributions. From my side, very many thanks for such an inspiring event.
Anna, what a way to wrap it up. Thank you so much. We now have about 25 minutes to have a general discussion, Q&A with all the authors and the participants. So I open the floor to anybody. I see Marie. Would you like to say anything, or should I pass the microphone to somebody else?
I think, anyone who would like to ask a question, raise your hand, or even show your face. I mean, I don't know if it's a good idea for everyone to show their face. But let's get the questions going, I think. But I wanted to say to everyone.
Yes, thank you. And until I see a hand raised, perhaps also just a brief comment that Anne picked up and several of you authors picked up on the lack of conceptual clarity. I would just like to play devil's advocate, and I said this in the beginning. I think we shouldn't just be critical of the court, but also really take into account, it's really challenging task of dealing with such a variety of cases and so forth. And so I'm just posing this question in general: do we want to have more clarity in the conceptual framework, always being at risk of then creating too high standards for either of the parties to meet? In this particular webinar, we've discussed cases with strong political interests prevailing, but what about the cases where the court uses this freedom of conceptual opaqueness, as we might call it, in favor of the applicants, for example, precisely to balance out this power and difference? So I'm just one thought that I'm throwing into the rounds, but I see Kristin already with her hand up, so I will hand over to you. Thank you.
Thank you very much. Okay, so a few points, and I don't want to take up all the time, so I'm going to make it succinct. First, I want to go back to Anne-Katrin's very fascinating presentation. I look forward to actually reading some of the outcomes of your research. It sounds really interesting. Your point about this pattern, right? Patterns of human rights problems, human rights violations, in patterns in the court's jurisprudence. Well, I would talk a bit broader in terms of patterns of problems that have been established by credible sources, like NGO reports about, systemic discrimination against particular groups and systemic issues of racial violence, systemic problems of racial profiling, etc. I mean, to my mind, it seems that the court tends to acknowledge it, but whether or not it refers to these reports, so it's aware of them, but it's just a question of political will, and I'm always a bit sensitive to use political will about a court, but it's a question of will, or whether it wants to actually really acknowledge it and pick it up. And that goes back to answering a question that I got from Kanstantsin. If you look at what the court does in regard to domestic violence, which it framed as an issue of gender discrimination, there you see a very different and more proactive approach and an acceptance that, when there are these reports of, structural problems of domestic violence with a lack of reaction by the public authorities, that is an indication of gender discrimination. So the court does it in some respects and not in others. So that makes you question. And that brings me to the other point, that the point of the fear of backlash that Violeta was pointing to, which actually seems to resonate quite well with how I have drawn the development lines of what the court was doing in regard to racial discrimination cases as being way too much, or giving too much weight to the concern about, not putting too heavy of a burden on the state. I think that is related to a concern about possible backlash as well, or can be related to that. Thirdly, quickly going to this question of the prima facie case, whether or not it should be defined. The sense is the court has identified these three criteria in the Nachova case, that general criteria, right, that resonate with more general practice in international and national courts in regard to human rights violations and non-discrimination in general. So then I think, why not actually engage with these criteria? I can see that it may be controversial, especially if it's about, concerning seriousness of violation, because that pushes the court to acknowledge that some violations of human rights may be more serious than others, which is now something which stays implicit, right? So I think that may also be a concern why the court doesn't actually go on with it, right? But it's just too controversial. And final point, quick point, also going back to what Violeta was saying about, basically states being getting a present because of wrongdoing in this, and that's what you see also, for example, in the racial profiling cases, where the court, especially in the Basu, or in the Mohammed case, where it's clear that there's a problem, the Basu case, sorry, when there's clearly a problem with a lack of proper investigation, whether there was racial profiling, the court says, yeah, because the investigation was so faulty, we cannot say anything about the substantive part. So basically, that's almost inviting states, well, if you don't want to get a finding of substantive violation of discrimination, just don't do a proper investigation, right? So that's about accepting and condoning and maybe inviting wrongdoing on the side of the state. A bit negative and a bit critical, but okay, I wanted to share these thoughts. And I think I've overused my minutes. Thank you very much.
Thank you. Nothing overused. Thank you so much for your comments. And I hand over to Kanstantsin and afterwards Joe. Thanks.
Okay, sorry. Yeah. Hello. As you can see, there is no sun anymore, so my question will be less persuasive than my presentation, unfortunately. Two very quick points, if I may, and most of them were inspired by Anne's incredible final remarks. The first one is about conceptual clarity, and I agree with Nele, who said that this might be a double-edged sword. It can also, flexibility might allow for better fairness. And that brings me to another question, practical question: how are you gonna impose conceptual clarity in evidentiary cases? Judges might say that, yeah, well, in this particular case we believe that, and this will be even more mess there, to be honest with you. Although I agree that some standards should be, some criteria should be there, but actually following up with this might be a problematic issue. The second point that I wanted to ask is in relation to Anne's point that the court is flexible and responsive to the challenges, current challenges. Is it actually a good thing or bad thing, right? Is it good that the court actually has some sort of ability to react, ability to adjust? I would say, like, if you want my brief opinion, I think that, like, of course, there should be some margin where the court would be able to shift and respond to reality. Of course, if there are some clear red lines that the court shouldn't cross, but within these red lines, some flexibility should be allowed, because it's such an difficult, complex, and multi-layered problem to keep 46, not 47 anymore, but still 46 states within its reach and within its ambit, so to speak. Thank you very much.
Over to you, Joe.
Perfect, thanks. Just one comment that I think has came up from a few papers, Grazyna's in particular, but also I think all three in the comments. And this is an issue that my paper touches upon, but I want to dig into much more, and I think it requires much more attention. And it's the East-West. I don't really like that distinction that much, but it's different treatment of different respondent states. Now, of course, there's plenty of legal mechanisms which justify different treatment based on internal procedures, thinking margin of appreciation, domestic scrutiny, and foreseeability of law and the quality of law analysis. But sometimes what we're talking about, and sometimes what we're seeing in these papers and these case studies, is differential treatment of different between respondent states in the court's evidential approach. Now, I think there are certain limited circumstances in which such differential treatment may be justified. I'm thinking here about Article 38, failure to comply in the recent Russian cases. But applying objective standards which are different, objectively different evidentiary standards to different states from the get-go without these kind of justifications, clear applications of Article 38 is deeply, deeply concerning in my regard, sometimes much more than the different legal scrutiny that's applied by the court. So it's a different direction, and I think Anne touched on that, but I think this merits some more attention. Thank you.
Over to you, Marie, and I also invite any of the other participants to participate in this debate if you'd like. Over to you, Marie.
Thank you, Nele. I'd like to go to this question of, should we leave things opaque and a bit inconsistent, because that gives flexibility to the court, and then it can work in both ways. It could be to the benefit of the state, but why not to the benefit of the applicant? And I would like then to have concrete examples of this happening, because I'm not sure that I can immediately see that. And I think that flexibility is important. But if we take, for example, the example of prima facie, which has been used a number of times, and which actually is also something that I have found in my own analysis of the second judgment, Ireland versus UK, so the revision, the refusal of the request of revision by the court judgment. There also, I see, and I saw that independently of reading the other papers, I saw, well, the court seems to be using the word prima facie, but it doesn't want prima facie. It wants something which is much higher than prima facie. I really do not see how this lack of conceptual clarity about the use of prima facie is something that we should cherish in any way. I think it needs to be clear what prima facie is. So where would it come from? Well, commentators like us can say it. Of course, it's not up to us what the court is going to do with it, but maybe some judges. I mean, we have seen some judges have said it as well. Actually, they have seen it. So that's, as far as I'm concerned, that's the job of the court. But I think clarity should enhance the jurisprudence of the court. And it doesn't mean that because there has been clarity, the court cannot yet explain, for example, why it wants to adopt a different standard and to say, in this case, prima facie is not good enough for us. We are going to require something which is higher than that, maybe, not as high as BRD, not as high even of direct and incontrovertible, something in between, because this and that. So I don't think that clarity then goes against flexibility. The flexibility will come out of the fact that, in fact, the court can decide everything about its evidentiary rules. So it can also say why it would apply a particular standard, why it would shift the burden of proof, why it would find inferences good enough. I mean, everything is possible. So that's what I wanted. But please give me examples of a flexibility which will have been used to the advantage of the applicant, even though that's not what we would have expected. And the other thing I wanted to say is that, a court which is generally reluctant to fact-finding. That's what one of the big findings of Anne's research. But I thought Anne was going to continue by saying, of course, we have counterexamples. And in their thesis, I think they will be using the case of El Masri, but that would be for them to explain. Thank you.
Thank you, Marie, and straight over to Anne.
Thank you indeed, and thanks for throwing over to me as well, Marie. It is of course true that the court can use the flexibility in order to be proactive in fact seeking. It rarely does so, as you say, but El Masri is a good case example. There are others as well, where, for instance, the court solicited expert opinions on its own motion. In one case, it used Rule 39 of the Rules of Court in order to order that the respondent state at the domestic level initiate additional investigatory steps and so on. But as I said, this is very much the exception. A quick response to Joe and Kanstantsin. To Joe, I think you couldn't be more right in underscoring the need for us to talk more about different treatment in terms of evidence of different respondent states. And we see this, I would argue, in particular in relation to how much deference the court is willing to give to states in their own assessment of the facts. Will it just basically rubber stamp what the domestic court said about the facts of the case and assume their evidence assessment was correct, or will it use stricter scrutiny in double checking if everything went okay at the domestic level when we had domestic proceedings, of course. And there it's difficult not to at some point to sometimes get the impression that different scales of scrutiny are applied to different states. Coming back to the issue of conceptual clarity, I would, of course, fully agree that retaining flexibility is important. And again, I think that this historic inquiry into the evolution of the court's evidentiary practice teaches us precisely that it's important for the court to be able to adapt to changing challenges. I also acknowledge that certain evidentiary or changes in the evidentiary practices are logically explained by the fact that the court is still in a caseload crisis, and it needs to adopt measures that will streamline processes. Sometimes those measures, by the way, can very much work in the favor of applicants in WECL cases and well-established case law cases, we see in effect that the burden of proof on applicants can essentially be lowered where the court is well aware of a structural problem. How do we impose conceptual clarity if that is what we want to strive towards? I don't think it's a matter of imposing it. Marie said rightly that we as commentators can help the court identify where we see issues. And I do think that there is a call to be made for more internal discussions on this, overcoming this uncomfortableness, frankly, that I've encountered when I spoke to people in Strasbourg when it comes to dealing with evidence. It's not something that everyone immediately jumped on. When I reached out to people to ask for a research interview, some of them came back to say, oh, it'll be interesting to discuss this, but I'm not an expert on this, or I will learn a lot from this because it's not something that I come across every day. So just, fostering that notion that evidence is important and that can make a massive difference in the cases is something that I think we can do as external observers of and friends of the court. Finally, is it a good thing that the court is responsive to contemporary and changing challenges? I would say so. If I would add something to that, is that not all changes are positive. I'm not a great fan of the court saying that fact-finding is no longer useful in this day and age. I think this is partly due to the fact that institutional memory has been lost in today's court about just how crucial fact-finding missions can be in unearthing the one crucial piece of evidence that can make or break a case. But it's true that the court has a general compass. So I'm not worried of the court suddenly overhauling its entire evidentiary regime or the evidentiary regimes just on a whim. This is not going to happen. Nobody can sort of steer the rudder so drastically in the completely opposite direction of where it's going to over the past 65 years. What I would add as a final point is that sometimes I think the reactivity of the court means that the court is a bit slow to respond to changing challenges. And I think we saw this in the Russian legacy cases, if you will. It took the court quite a long time to even decide how it would deal with the Russian cases once the convention had ceased to apply to it. And one of the reasons for this was that it struggled to figure out how the court that is so prone to putting emphasis on the adversarial process would deal with a situation where one of the parties is just not present, cannot submit factual and other arguments. So that to me is something where I think greater engagement internally with matters of evidence can actually help prepare the court better for drastically changing challenges that it might be facing in the future. It might relate to climate change cases, which Nele is analyzing, or to the use of open source digital evidence. There are manifold, and I think the court should better get a head start on tackling them.
Could I come in on just this, Nele?
Yes, sure. Go ahead.
For 30 seconds as a continuation of what Anne has just said. State which refrain from participating in the proceedings does, it's like, what can the applicant do? It's not, the state is not going to provide any information whatsoever. I think that is a good example of where we could expect the court to say, we are going to shift the burden of proof. This is not, the state must be in possession of some evidence, and it is not submitting it. We shift the burden of proof. But this is where, if you remember my scheme, it may be interesting then for the court to explain in its judgment whether the presumption of the violation as a result of this, as it will not have been rebutted as the state has not participated. So whether the presumption of a violation is just on the balance of probabilities, it's because we don't know better, so we assume, or whether it's something stronger. As I said, I think that in some cases, even through presumptions, you can reach a conclusion which is beyond reasonable doubt. So, and to me, it's quite important that in the case law, the court begins to in a sense, give guidelines as to whether the violations is absolutely certain, or it's on the balance of probabilities. We are not in criminal cases, so we don't need to worry about, in a sense, the problem of the presumption of innocence. That would be my view, but of course I'm going quite far. Thanks, Nele.
Of course, thanks, Marie. And we will have Violeta as our final intervention. Thanks.
Thank you. Yeah, more on the point about clarity and conceptual definitions and so on. I mean, I appreciate that defining the notion of prima facie would attach the risk of lifting the standard too high, as some of you have already said, and relinquishing maybe the possibility for opaqueness or flexibility, or however we want to call it, to favor the applicant, or rather favor the delivery of justice overall. And maybe defining prima facie would not be such a big problem if we were not faced, in addition, with the proliferation of different but similar terms that we have encountered in the case law that each entail a different standard. So coming back to the point that I was making in my previous intervention, to the arguable claim threshold that applies in the context of Article 34, should the standard be the same as prima facie? Should both be assimilated? I think this is a legitimate question, particularly when both appear to be pointing in the same direction. And then if the court were to drop one of them and retain only the other, perhaps that would in itself contribute to the clarity that we are wishing to encounter, and that it's required at the end of the day by the rule of law that underpins the entire convention system, while at the same time would also avoid the constraints of having immediately at least a fixed definition. So I think that there are different strategies that some of you have already pointed out that the court could engage in, rather than providing, you know, like a dictionary definition of what prima facie means. I mean, there are things that could be done for the cleanness and neatness of the understanding of the different notions that are being thrown at applicants in the case law that would already contribute to a better understanding of the notions at stake and contribute to a more rule of law based understanding and interpretation of the convention. Thanks.
Thank you so much, and a big thank you to everybody. First and foremost to Marie for organizing this, for taking the lead on, really establishing the initial webinar and then following suit with the special issue. I think this goes to show, and just to reiterate Anne's point, evidence is at the heart of human rights adjudication, and I think it's about time that we discuss and really kind of shine a spotlight on this issue. And so with these words, I will close these current proceedings, but I also declare that we are far from finished, and so to be continued. Thank you so much.